with the most, King Truth, Hosenberg, Bitty Bo, the one with the word, the one with the flow. And we coming at you live, man, at 9:52. And we got some content for you. Rapper Ynw Melly attends hearing after judge keeps dates for rapper's double murder retrial. Basically, they got Melly in there for a minute, man. Melly's been up in there since I think like 2017. And they've been switching up his trial dates for a minute, so he ended up just going off on the lawyer. So we go watch a clip on basically them talking about it on the news, and then I'm gonna play the clip of the court session where he kind of speaks his mind to his lawyer real quick type shit. And yeah, man, let's get into it. Everybody with me, man? Where the... Oh, all right, man, here yet. All right.
For Ynw Melly's double murder trial, ordered documents related to his defense attorney be turned over. Melly, whose real name is Jamal Demons, is charged in the killings of two friends back in 2018. His lead defense attorney, Raven Liberty, is under investigation by the Broward County Sheriff's Office. Her team wants to see warrants related to the 18-month-long investigation that until now have been off limits because it is an ongoing police investigation. Demons' first double murder trial in 2023 ended in a mistrial when jurors couldn't agree on a verdict. His second double murder trial is slated to begin September the 10th.
Okay.
Watch to the end for a discount code to Restream's Upload and Stream. Being a content creator can feel like you've always got to be on, always live. It's overwhelming. So stream smarter. Upload your video to
So I would ask the court to inquire from the state if this is truly an ongoing investigation. When is it going to come to a head?
The lawyer getting irritated. He said, if this is truly an investigation, then when is this shit going to come to a head? They've been doing this shit for years.
Today, tomorrow, or in the middle of this trial.
Ynw Melly. Remember him? He's charged with 2 counts of first-degree murder, accused of killing his 2 childhood friends. Now, he's already been in jail since 2019. And yes, he's already been on trial once. But we know how that ended.
They have further discussions, reviewing the evidence, speaking freely amongst the jurors. You're still unable to reach a unanimous decision. So at this time, what I'm going to do is just declare this trial.
Now, that mistrial was declared back in 2023. Since then, there's been a slight change at the defense table, and there's been a prosecution shakeup too. And in a surprising move, the state wanted some more time before retrying the case. But does the new judge overseeing the case agree? Thanks for joining us on Law and Crime. I'm Elizabeth Milner. Now, it's been a while since I talked about Ynw Melly, mainly because I was covering another high-profile case right here in New York. But over in South Florida, Melly remains where he's been, in lockup. Now, depending on the outcome of his retrial, he's facing anywhere between life in prison or the death penalty if he's convicted. Now, when does his retrial begin, you might be wondering? Well, in about 2 months, despite a push for a delay.
February of 2019, Mr. Demons voluntarily surrendered and was charged with 2 counts of first-degree murder, wherein the state indicated they were seeking the death penalty if, in fact, he was found guilty. In October of 23, Mr. Demons was rearrested for tampering with a witness, directing the activities of a criminal gang, solicitation to commit tampering, and conspiracy to commit tampering.
So that was a little snippet of the charges Melly faces, but I'm sure those following the case already knew that, and likely already know the allegations in the case too. Melly, his friend Cortland Henry, and their friends Christopher Thomas Jr. and Anthony Williams were all at the studio together and all hopped into the car together after the late night recording session. Christopher and Anthony never made it home that night. Back in October of 2018, they were killed in a drive-by shooting. But prosecutors allege it wasn't random. It was someone from inside the car that made the fatal shots and staged it to look like a drive-by shooting. Prosecutors allege Melly pulled the trigger and Cortland helped cover it up. And while I talk about how Melly's been in jail for more than 6 years, it's been nearly 7 years since Anthony Williams and Christopher Thomas Jr.'s families' lives were changed forever, with no closure on the case so far. So Melly's mistrial happened in late summer of 2023. Now we're approaching late summer of 2025, and Melly's trial is going back to square one. Well, kind of. His retrial is now moving forward in September of this year, despite objections from the state who wanted a delay in the trial.
I have the state's motion to reconsider or order moving forward with the trial on September the 10th. The trial date remains set on September the 10th. I did that last July 8th, 2024, although there's no motion to continue filed. I did read the motion. I guess I'll treat this as a motion to continue. I did read the authority cited therein. I did read again, Florida Statute 924-071. Additional grounds for appeal by state, time for taking and the stay of cause. I likewise again reviewed the omnibus order on defendant's motion to suppress 1 through 13, which was entered by Judge Murphy on December the 20th, 2023. I also reviewed the order from Judge Murphy denying the defendant's motion to set aside stay, and order granting defendant's motion to modify the stay to allow discovery to proceed. That's entered May 2nd, 2024. I likewise reviewed a Florida Supreme Court case called Mitchell versus State, 911, 7-2, 1211. Supreme Court case of September of 2005 regarding serious constitutional issues that are implicated if the state were to be automatically entitled to stay the effect of the decision adverse to the state in a criminal proceeding. So, understanding that I've already looked at all of that, Stace, anything else that you would want to tell me in support of your motion?
No, Judge. My motion basically covers the previous court's orders, the statute, the case law in terms of how this case is stayed.
Okay. Defense, do you all want the case to be stayed? The state says it's stayed, so do you agree with their motion? Or do you not agree with it?
We have one more motion.
Sure.
Yes, sir. Against our advice, our client wants to proceed.
So you object to their request for me to determine if it's automatic stay.
Based upon what our client has instructed.
Motion's paid, man. I'm trying to hear his court shit. What'd he say? No. What are you doing, Dad? That shit looks real, huh? That shit looks hella real, bro. Alright. Y'all go over there, man, to bring the facts, man. I guess he didn't do nothing on it. Hell, he did something on Shannon Sharp. Oh, fuck, that's the one I was supposed to do Cash Out. I was supposed to do no YMW Melly, man. It's good. We go,
Yes, sir.
Okay, so let me make the record crystal clear on this one as well. I am aware that 924-071 calls for an automatic stay while the state is appealing some orders they want to appeal. In this particular case, Mr. Dennis threatened to be charged not with appeal. So, state, let me ask you what I'm going to ask you. Judge Murphy entered this motion to suppress, which is the subject of the appeal right now. He entered this order on December 20th, 2023. That was 568 days ago. And in that order, he says at the end, the court has not been moved to consider the suppression of specific evidence. It is up to the party and inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible pursuant to that order. Then we were here on the defense review motion for bond on May 6th. That was 65 days. I asked you all, had you gotten together and figured out what specific evidence falls within the suppression order?
Today I'm going to make a beat. We're going to output a new plugin co-producer, play your beat. It's going to analyze it, G minor, and then describe funky electric organ. Yes, that's what I wanted. Check out output co-producer and
That's what I wanted.
I'm going to guess that hasn't happened.
No, Judge, I made the proffer to the court last time.
The way that the prosecutor is looking at the judge. Tired of your shit, Judge. We've been fucking doing this trial for years.
What that evidence would be.
It was basically penalty
This shit.
for lack of a better term.
No, they were aggravators. They go to membership in a gang. There were things that the jury would have to find before going into penalty.
Not aggravators as to the death penalty,
Right.
aggravators as to the gang enhancement itself, Your Honor. That was charged. He was charged in committing the murder for the furtherance of a gang, which is an aggravator in terms of the guilt.
Something that they would have to find by way of an interrogatory.
Yes.
Yes.
No, objection, that's not true.
That's not correct.
So you all don't agree on it.
No, we don't.
No, what you just said, we do not agree on. There is, I'm sorry.
Have you all done what Judge Murphy ordered you to do in 2023? It is up to the parties to inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible pursuant to this law. Have you all done that?
May I answer the question this way? At that time, the state appealed it all, which stayed everything. And so at this point, the law on whether or not Judge Murphy was right or not is all up at the fourth, and it stayed. We can't determine that in a stayed case. It stayed.
You can't talk to the state and decide what this applies to.
I just argued what I have to argue, Judge. You're saying it stayed for only one
I
purpose,
want you to
but
answer
not.
my question.
The answer is we are stayed and unable to do so.
So you don't even know what evidence the order is.
No, I believe we do, and I think that's on appeal at the fourth. But during a stayed case, we cannot do those things. And that's why it hasn't been done. Not because we haven't wanted to. They appealed it. It stayed.
Unfortunately, to also remind the court, the defense did cross appeal, so even stuff that would remain in is also potentially can now be excluded should the fourth rule in the defendant's favor.
And that's still pending before the fourth.
But you don't agree with their request. You want to go forward. That's what you just told me. Your client wants to go forward.
That's what he said.
So according to the Sun Sentinel, the original judge on this case, Judge John Murphy, ruled prosecutors wouldn't be able to reuse some of the technological evidence the state presented to help establish Melly's alleged motives, gang affiliation, and consciousness of guilt. The appeals court has yet to rule on if those restrictions will still stand and are supposed to hear arguments about it on September 16th, a week after Melly's retrial is supposed to begin. But as you just heard from the judge, the case is still set to move forward on September 10th, and the issues in front of the appeals court aren't enough to delay the trial. But the state isn't the only one suffering some issues too. The defense is too. They accuse the Broward State Attorney's Office of prosecutorial misconduct, and Melly faces another charge of witness tampering. Oh, and one of his lawyers is under investigation. But as of this recording, she doesn't face any charges.
I don't know how we can properly defend Mr. Dennis on the evidence of tampering with a witness, solicitation, conspiracy to tamper, when we don't know all the facts. So I would ask the court to inquire from the state if this is truly an ongoing investigation, when is it going to come to a head? Today, tomorrow, or in the middle of this trial? And how come you have not pursued, when you file a memorandum of law, saying that Ms. Liberty must, regardless of what Mr. Demons wants, regardless of what the defense team wants, must get off this case?
I don't know how they can do this.
So Melly's trial is moving forward in September, nearly 7 years after Anthony Williams and
I say finally, man. It just says 7 years, bro. After since it went down, I think it went down 2016 or 17 though, because he made Murder on My Mind. That shit dropped 2017. So I think he was charged and sentenced like 2019. It was 18, but they didn't fully do the sentence until 2019. So still, that's a long time, man, to just be. Because you see Thug's case, man. Thug's case was about 3 years. So definitely, Melly's been in there for a minute, man.
Christopher Thomas Jr. were murdered. How will his retrial differ from his first trial? Well, I guess we'll have to wait and see what happens. But let's break it down with criminal defense attorney Safa Robinson Ferrer. Safa, first of all, great to see you. Like, I haven't seen you in a while in this format, I should say. But
just see you, Queen Elizabeth.
Yeah, oh, thank you. But I'm curious, like, on your thoughts on this case, as opposed to what we were normally talking about, which was Diddy. But in this case with Ynw Melly, are you surprised that the judge said, let's move forward with the case, even though the state was waiting for whatever the appeal court was going to say about restrictions, like technological evidence, gang affiliation, all of that stuff? But are you surprised the case is moving forward in September?
I'm not surprised at all. Mr. Dimmons has been waiting in custody to see a trial on this case since, I believe, 2019. You know, he obviously went to trial before that, ended in a mistrial, and he's remained in custody since that. And he has a right to a speedy trial, a constitutional right to a speedy trial. And I think in this particular case, the judge is trying to ensure that. So it's not surprising here that the judge is saying, no, we're going to trial on this particular date and everybody needs to be prepared to move forward.
And I thought it was interesting too, because just watching back the hearing, it was actually Jamel Dimmons, aka Ynw Melly's decision to move forward with this against the advice of his attorneys, his defense attorneys. What do you make of him kind of pushing himself to kind of get this trial going just to see what's going to end up happening?
Yeah, you know, I think at the end of the day, he's been sitting there for quite some time and he just wants to move forward with his life, whether that is an acquittal so that he can get back to the public and get back to his work, or accept his fate as a convicted felon, someone that has been convicted of 2 counts of murder. So a lot of times with clients, and particularly defendants, they don't like to sit in limbo. And considering, again, he's been in
Wix, one platform, any website, unlimited creation. Describe your needs and goals.
Custody since 2019. So we're talking years. We're not just talking a year. And we saw how quick Mr. Combs' trial went to trial, or Mr. Combs' case went to trial. Mr. Melly, or Ynw Melly, has that same exact right. And so it's not surprising to me that he wants to just get it over with, you know, and he probably expects or thinks that he's going to have something favorable to him as he commences on this trial, considering that the other trial landed in a mistrial, which essentially for that moment was a win for the defense.
And I think he was even hoping that there would be a possibility he could be out on bond or bail. And then obviously that didn't happen. He's remained in custody since. So I can understand why he wants this to move forward, just to see what's going to end up happening. And given that this is a retrial, who do you think has kind of a tougher hurdle to overcome? Is it the prosecution? Is it the defense? Especially knowing that the offense that had happened, that being the double murders of Ynw Juvie and Ynw Sack Chaser, Anthony Williams and Christopher Thomas Jr., happened back in 2018. Who do you think has the tougher hurdle for this retrial?
I think that the tougher hurdle is always going to be remain with the prosecution, because it's their obligation to prove his guilt beyond a reasonable doubt. They have to prove each and every element of each and every homicide offense beyond a reasonable doubt that he intentionally murdered these individuals. And that's always a hurdle. That's always a burden that the prosecution has to get over. At the same time, there are things that the defense is really going to have to work on here. This case landed in a mistrial previously, so the likelihood is that, again, if they came back hung, that some believed that he was guilty and some believed that he was not guilty. And so the defense is going to really have to hit away at the prosecution's arguments and theories that Mr. Ynw Melly committed this murder. And so I think that both of them have a job to do, and it's going to be a pretty tough job on both sides. I think the prosecution's hurdle is a little bit higher than the defense.
Yeah, because again, they have to prove the case beyond a reasonable doubt. And is there a possible doubt that may linger? It'll be, I guess, up to a jury to decide eventually when that happens. But there are a lot of high stakes in this case, too. Not only is this first degree murder and 2 counts of first degree murder at that, but it also could be a death penalty case if Melly is convicted. What do you make of just the high stakes, especially that he is facing the death penalty?
Very, very, very high stakes in this case. And he's got everything to lose. He's got his life to lose. So this isn't just a case here where he's going to be spending the rest of his life in prison. This is a case where he could be set to death because of this conviction or because of these convictions. So with respect to the defense team, they're really going to have to do a very fine-tooth comb job with cross-examination, making sure they cross their T's and dot their I's, and essentially save his life on the back end. If he is convicted, then they will enter the penalty phase, and his attorneys will argue, for him to remain in prison for life. The prosecution more than likely will ask for the death penalty based on the deaths, and the judge, or in Florida, I'm not sure if it's the judge or the jury that makes that determination, but ultimately the stakes are significantly high because he does face the death penalty.
Yeah, and it's interesting too, because I remember when this case first happened back in 2023, or I should say the first trial happened in 2023. And I was always curious, especially about the death penalty aspect, given that a law came down. It doesn't have to be unanimous. It just has to be kind of a majority thing. And in terms of that, what do you make of that? The jurors don't have to be unanimous on deciding the death penalty. It really just has to be kind of a majority, either go for it or they go against it. But what do you make of just that added layer to it?
That's a pretty difficult layer. And, I'm of the opinion, of course, as a defense attorney, that, they have to have a unanimous guilty verdict. I think that they should make a unanimous decision on whether or not to put that individual to death, or for that to be that decision to be in the hands of the judge who may be more equipped to handle or to make a decision like that, as opposed to lay people from the public who may not fully understand the law, may not understand certain things with respect to the death penalty. So I'm of the opinion that they should all unanimously make that decision. The fact that it is, based on a majority, of course, that's what Florida determined to be, their standard. And so, unfortunately, if he's convicted, then they will have to deal with that.
Yeah, and it, obviously we're months away from, that possibility, because it could go in the completely opposite direction. We just never know with cases like this, because I even remember back during the first trial, it was like Melly, was kind of adamant that he was inside the car. He even made that kind of video at the end. It said Melly and his friends were victims of being in drive-by. Then he kind of did an about face. His friend came on the stand and was just kind of like, oh no, Melly was actually here. He wasn't in the car when this happened. None of that. But do you think that we could get these kind of like bombshell shocker moments in the retrial? Or do you think it'll be more or less possibly the same as the first trial?
I think it's going to be pretty similar to the first trial. And I know that there were some bombshells that were dropped in that first trial. And the defense particularly is not going to want to shy too far away from whatever the testimony was, or whatever the testimony that was provided to them in favor of them during that first trial. So, whoever's going to testify on behalf of the defense, if they testified during the first trial, they don't want to get back on the stand during this trial and say something totally different and totally opposite. It's going to destroy the credibility of the defense's theory in their case. So they got to be really careful with that. And same for the prosecution, depending on who they call as a witness. There was clearly some sort of doubt that was laid out during that first trial. And I think that the defense should continue to pick away at that and go at that, because the prosecution didn't have a clear-cut case then. They don't have a clear-cut case now, which is why this case is going to trial again.
And also, really quick, Safa, I just want to clear up something I had mentioned earlier, just about it being a majority rule. It really just has to be 8 people in 8.
When lawlessness tips the scales, justice comes in waves. The marshal stands alone, outgunned, but not outmatched.
8-juror majority in order for the death penalty. So still a majority, but it has to be at least 8 people, which still is pretty scary to think about if you're a defendant in a case like this. But also with us being kind of months away from this trial, or really 2 months at this point, how important do you think jury selection will be in a case like this? Obviously, from other high profile cases that we've covered, it's very important, this voir dire process. But in a case like this, where the stakes are high, including even death penalty as a possibility, how important do you think jury selection will be?
The case is won or lost during jury selection, and we say that all the time in the legal profession. In this particular case here, the defense is going to want jurors specifically that are quite religious. And so, as we're preparing for voir dire and jury selection, we're thinking about the ideal juror that we would want. Even as a former prosecutor, the prosecution's ideal jurors, the defense's ideal jurors. In this particular case, with respect to people who are heavily involved in religion, oftentimes they come out as great jurors for the defense because they don't like to hold other people in judgment. They believe that that is the responsibility of God or a higher being. And so not wanting to hold someone in judgment, they don't like to usually find individuals guilty. Not only that, but if you're talking about the death penalty, they don't want to take a life. They don't think that that is their responsibility or their decision to make. Also, you want people, from the defense aspect who can relate to Ynw Melly, who may be fans, who may, believe in him, believe in his case, young Black men, young Black individuals that may relate to him to some extent. And from the prosecution, you're going to want individuals who, are very law and order, very law enforcement, very geared towards, believing the police, believing in law enforcement. A lot of people who love true crimes, they're oftentimes, more favorable jurors to the prosecution as well.
I mean, I feel like, the fuck, is my shit muted? Y'all hear me? Yeah, I feel like, basically, like, he's got some people that are with him and some people that are against him. Like she said, like certain people that are trying to support him, and he got certain people that want to see him put under the jail. You feel me?
Well, so each side has their different pickings of who they're going to want. They're going to try to knock off each and every person that the other side wants until they get that happy medium jury.
And it's interesting you say that, because I was thinking maybe the defense would want to go for the younger jurors too, but you saying the religious jurors, that kind of makes a lot of sense.
Yeah, I've had a ton of cases where I'm voir diring and I've had someone raise their hand and say, I'm Catholic. I can't hold someone in judgment. I can't find somebody guilty. That's not my job. And so it actually happens quite frequently.
Let's get to 20 more subscribers, man. We have 4,000, man. We're trying to reach that 4,000 goal, man. Once we reach that 4,000 goal, it's gonna be a giveaway. But we had 3,780, man. We need 20 more subscribers, man. We're gonna go to 4,000, man. So let's get there, man. Let's get there. All right.
Yeah. And I want to also go back to a point that you had made earlier, just about how important the cross-examinations will be in a case like this. Obviously, seeing the Diddy trial right in person, I saw how cross-examinations can really, really do wonders for the defense. And in turn,
it's so easy to become a podcaster with Riverside. You just need a concept and a way to record it. Here's how it works. First, go to riverside.fm and open an account, and then you'll be able to capture high-quality video and audio from practically.
The trial is starting tomorrow. And then that's September the 5th, 30.
Bro is not happy today.
I don't even understand what frequency you are. This is a death penalty.
And Judge, the heightened
No, now it's my turn to talk. So you all decided, for someone who's already facing capital charges, let's open up a new case. You could have done all this the day after his murder trial was over. You could have done all this.
Oh! Ynw Melly appeared in court for motions and goes against the advice of his lawyers. Melly is seen snapping at his lawyers over the stay in the case. It seems Melly doesn't want any more delays himself, but his lawyers advised him to keep the stay on the case and delay the trial. The state wants to delay the trial as well. You're going to see what the judge does towards the end of this video. If this trial gets delayed, it wouldn't happen until 2027. That's what the judge says. Watch the full video, hit subscribe. Let's go.
That's fucking crazy work, bro. 2027, that man's been in there since 2019, 2021. That's almost like
Go. All right, stream cuts on late. So we're out of scene. Melly's lawyer's already talking.
2027 is like 11, 12 years.
And here's Mr. Griffiths from the state and the judge. Let's go.
2019, rather. Mr. Demmons voluntarily surrendered and was charged with 2 counts of first-degree murder. In October of 23,
I'm sorry, this guy's face right here.
Mr. Demmons was rearrested for tampering with a witness, directing the activities of a criminal gang, solicitation to commit tampering, and conspiracy to commit tampering. As a result of that, the state provided supplemental discovery in the murder case and represented to the court on numerous occasions that the tampering case is intertwined with the murder case, and they expect to introduce evidence of the tampering case to a certain extent for consciousness of guilt.
Yeah, we've known about that. They're trying to show Melly was trying to silence his girlfriend. Remember the whole coded language bullshit. He's guilty. He's trying to hide witnesses from the court, blah, blah, blah. You get the picture.
A year transpired, and in December of 2024, the defense learned that a search warrant was executed on a member of the defense team's Apple account, Miss Liberty's. And they withheld that evidence for over a year. And I would submit to the court that had not Apple notified Miss Liberty a year later that a warrant was executed, the state probably would have concealed that point as we stand here today.
Still crazy to me. We already know all this. Everything, the entire iCloud account was taken by the state of a lawyer.
And the court originally indicated that the state was to produce to the court the affidavit and the warrant. The following day, the court modified that and told the state to produce a copy of the warrant only to the court, and that the court would, in fact, do an in-camera inspection of that warrant and decide whether or not to reveal a portion of that search warrant or the total search warrant. On January 14th, before the court ruled on the warrant, the state filed a memorandum of law regarding attorney conflict, setting forth that regardless of if Mr. Demmons wants to waive any potential conflict, the court must basically throw her off the case. And they cited various case law. And I agree with the state that the court does have the inherent responsibility or authority to remove an attorney based upon the nature of the conflict. I agree with that. And it's been done in state court and it's been done in federal court. So we're in agreement with that portion of it. As we sit here today, 18 months later from the execution of this warrant, Mr. Demmons does not know the full extent of the conflict, nor do the lawyers know the extent of where this conflict exists, other than they executed a warrant on Miss Liberty's Apple account.
Seems a bit unfair, right? I mean, this guy is facing the death penalty, and we don't know if one of his lawyers is going to be arrested at any moment. And the trial's in 2 months or 3 months.
In July of 2025, saying that she must get off this case. And if they really believe that, they should pursue that, because that would be the first issue on appeal if he's convicted of anything.
Damn. They're like, we're already going to appeal this shit. That's the first issue right there if he's convicted. I mean, we all know if Melly is found guilty, there's going to be some appeals, right?
Yeah.
Like, there's going to be a...
All right, y'all. So we got this one, this one, this one, and this one. And we're going to go to the next video.
Whole big process, bro.
And I suggest that the court should hold a hearing on that and divulge the extent and what the conflict really is.
If you're new to the channel, please hit subscribe. I appreciate the support. Back to the video, boys.
For over a year, the state came into court and said it's an ongoing investigation. And as a result, they are allowed to conceal that, and it doesn't come under the discovery rules to provide that information. And the court in its order, and I think paragraph 4, stated, this court does not agree that the search warrant is part of an ongoing active investigation.
So they lied. The judge is calling them out that they lied. Remember that?
As of January of this year, Miss Liberty has not been arrested, nor is she a defendant in any pending prosecution, despite the fact that the state has had this information for over a year. Well, they now have that information for over 18 months, a year and a half, and they're still alleging that it's an ongoing investigation. The interesting thing about Your Honor's order, everything was interesting, but you gave the state an opportunity to appeal Your Honor's ruling and said, I would not divulge the warrant.
And they didn't appeal it. You gave them a time frame, and I'm pretty sure they did not appeal it.
You have until February 7th, 2025 to appeal the finding of this court that this is not an ongoing investigation. They did not take an appeal. And I suggest to the court that the law in this case, as we stand here today, is that there is no ongoing investigation as it relates to anybody in the defense team.
There's first look at Melly. That boy's smiling, like always, looking over at his family.
A continuing obligation to disclose any information that would lead to relevant information. They have not disclosed the affidavit. They stand here today and say it's still an ongoing investigation.
Raven Liberty and his mom have not spoken. They're not on good terms, so that's pretty awkward.
And one of the definitions is it's something that will occur soon, at a time that is not long from now. They've had 18 months to sit on this, and they've done nothing except come in here and conceal this to the defense. I don't understand that. If they say it's foreseeable, when? When are they going to take action? 18 months is a long time for us to sit here and worry about what's going on. Now, I do thank the state for citing the Hill case in their memorandum, their addendum, because in the Hill case, they said the court, the appellate court said that the court was right in not disclosing the affidavit because the charges of Mr. Hill were different than the charges that were based on the search warrant. And they said it would not lead to any fruitful or relevant information. The search warrant in this case, tampering with a witness on a capital felony and directing the activities of a criminal gang, which is exactly the same charges that Mr. Devins faces in the tampering case, and which they come into court every time we're here, and it's brought up, saying we're going to use some of that evidence in the murder case. They can't have their cake and eat it too, Judge. As we have said, this case is different from most cases because death is different. If Mr. Devins is found guilty of these charges, he's looking at the ultimate penalty of death. The rules provide that they have a continuing obligation to disclose all information that could lead to relevant information in a timely basis. As we sit here today, we're 2 months away from trial. We've waited 18 months for them to disclose it. We attempted.
Don't upload your videos to YouTube. Upload to Restream, where we will live stream it to YouTube and all your platforms at once.
To bring in Detective Luna.
Detective Luna was the detective that, on a deposition, she refused to answer questions. And Mr. Griffiths, the one standing right there, stopped this detective from answering questions with the ongoing investigation and said the judge was wrong. Straight up said, the judge is wrong. There is an ongoing investigation. We're not answering questions in this deposition about that.
Despite Your Honor holding, this does not qualify under the statute as an ongoing investigation. They said, this, Your Honor was wrong, period. Now, I got to tell you, that takes guts. That takes a hell of a lot of guts for a lawyer to come in here when they had an opportunity to take this up to the higher court and say you were wrong and do nothing, absolutely nothing, except impede our investigation to properly prepare for trial.
I used to have a big, ugly brown wallet that would take up so much space in my pocket and would always fall out. But over 6 years ago, I got sponsored by Ridge and have never used another wallet.
Two phones. There were 4 accounts listed, and they only gave us 2 accounts.
Interesting. So they did hand over, but only half of it, it sounds like. And this is a reoccurring thing with the state, that they keep not handing over everything the judge orders them to hand over.
I don't know how we can properly defend Mr. Demons on the evidence of tampering with a witness, solicitation, conspiracy to tamper, when we don't know all the facts. So I would ask the court to inquire from the state, if this is truly an ongoing investigation, when is it going to come to a head? Today, tomorrow, or in the middle of this trial? And how come you have not pursued, when you file a memorandum of law, saying that Ms. Liberty must, regardless of what Mr. Demons wants, regardless of what the defense team wants, must get off this case? I don't know how they can do this. So I'm asking Your Honor to not only compel Detective Luna, because we agreed to recess the depo, to answer questions about her participation, but also to produce that affidavit forthwith.
Oh boy, Mr. Griffiths right here from the state is about to respond. Here we go. Yeah, Melly's mom is there.
That's the bottom line. They totally ignored Your Honor's order when you gave them every opportunity to appeal. Thank you.
This has been an ongoing problem. I thought I had previously explained this to the court and counsel. I will do it again. The 23 case, the tampering case with which Mr. Demons and his co-defendants are charged with, has nothing to do with the Apple iCloud investigation. I believe we even said in court that anything that came out as a result of that iCloud investigation would not be used in his homicide trial. I think we made that very clear to the court. They're completely separate entities. So the fact that they're imputing what's happening in the 23 case and we intend to use that in trial, and I believe we filed a motion, that remains true. But that investigation has nothing to do with this. This is actually a separate investigation stemming out of a separate incident. The court twice previously has refused to turn over the affidavit, meaning the court has refused to let the defendant and his counsel know the nature of the investigation. I stand before this court today, it is still an open investigation, which is why I filed the motion for in-camera hearing. Because the court also pointed out last time when we were here that you had not taken any testimony, and so the only decision that you could make that whether it was an open investigation or closed was the fact that only time had passed. I included in my motion the fact that there is case law that states that there is no time limitation on how long an investigation can take. They take as long as they take. I'm sure the court's aware that investigations involving like embezzlement and other crimes take longer other than like a simple delivery case. I still take that same position I've taken before, which is outlined in my motion, that they have brought forth no new facts, no new issues, whereas the court has previously denied this issue, denied them the affidavit, denied them knowing what is going on with this open investigation. And so they bring nothing forward to the court today. So really the order of the court stands, which is they're not entitled to it. We again are prepared to take that next step, conduct the in-camera review, so the court can have an insight into the nature and the state of this investigation. We didn't feel that a hearing or an in-camera review to make that determination was necessary, but again, the court already ruled on it, and we simply provided the court with a memorandum of law. So at this point, they provided nothing new to establish why they need to know the nature of this investigation and where it is and what's ongoing with it. I understand everybody's frustration, it's taking a long time, but the case law allows for that. So where they are now is they have access to the warrant. We're in a similar position, just like the Hill case, where we dealt with a confidential informant in an ongoing investigation. And the court, even without conducting an in-camera hearing, said, because this doesn't deal with anything related to the affidavit, there's no need to conduct it. He's charged with something separate. Mr. Demens is charged with something separate. And so candidly, there's no point for even an in-camera hearing. It just needs to be denied outright, but we're still. No, I mean, no, but I understand where the court's going with law enforcement. Yes.
And the state did that.
Yes.
Okay? So you all decided, for someone who's already facing capital charges, let's open up a new case. Let's charge him with a new crime, which should lay him in prison for the rest of his life. So you're
The judges said some real shit. Y'all decided to just sit there and come up with a new case, charge him for a new crime. Now it's a new trial. New trial set date. Blah 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 blah. Talking about 2027. It's crazy work though.
I don't know what to tell you. You could have done all this the day after his murder trial was over. You could have done all this.
Boom. They didn't have to do this if you think about it, because then they're bound by the rules of discovery and they have to give over everything. They can't be hiding shit.
You chose to do it when you chose to do it, so be it.
No, not the 20. So the court's clear, for the record. The 23 case has nothing to do with this Apple iCloud affidavit or with what Detective Luna potentially testified to in terms of her work in this new investigation. They have nothing to do with each other.
Sir, if a law enforcement officer hypothetically showed up at my door asking to serve a search warrant on anything that belonged to any lawyer who's currently litigating a death penalty case, I would decline that request and probably ask them to leave the courthouse. Okay, so that's just my view.
Oh, he said I would have not wrote that search warrant if I was the judge. I wouldn't have given her the search warrant that's a lawyer on a death penalty case. So he's kind of shitting on the judge that signed that warrant.
States, anything else that you would want to tell me against? What are your motions?
No, Judge, my motion basically covers the previous court's orders, the statute, the case law in terms of how this case is stayed.
Okay. Defense, you all want the case to be stayed? The state says it's stayed, so do you agree with their motion?
Can we get 1 moment?
Sure.
The state wants the stay to stay in place because of the whole appeal nonsense. They're trying to delay the trial. The state doesn't want to go to trial in September. So that's what's happening here.
Hollywood is a place where are sacrificed. So this is not just trafficking that.
I wonder if I get banned off of YouTube, but if I sign up for this shit and watch this documentary, but I react to it, but oh nah. Oh, say though, like Melly was cussing him out though. Let's check it out. Yeah, here.
He seems angry, right? He was snapping at them.
Yes, sir.
Against our advice, our client wants to proceed.
So you object to their request for me to determine if it's automatic stay.
Based upon what our client has instructed us, yes, sir.
What? Melly's going against the advice of his lawyers. He's objecting to the stay. His lawyers didn't want to object to it.
I am aware that 924-071 calls for an automatic stay while the state is appealing some orders they want to appeal.
They were aggravators. They go to membership in a gang. There are things that the jury would have to find before going into penalty.
Not aggravators as to the death,
Sorry.
aggravators as to the gang enhancement itself, Your Honor. That was charged. He was charged in committing the murder for the furtherance of a gang, which is an aggravator in terms of the guilt.
Something that they would have to find by way of an interrogatory.
Yes.
Yes.
The aggravators with the whole gang bullshit. I've said this over and over. If Melly killed them, this has nothing to do with any gang. The gang is just an aggravator they wanted to add in for the death penalty.
Objection, that's not true.
That's not correct.
So you all don't agree on it.
No, we don't.
No, what you just said, we do not agree on. There is,
I'm sorry. Have you all done what Judge Murphy ordered you to do?
So Judge Fine or whatever in 23 ordered them to figure out what evidence falls under the suppression order. And apparently they haven't done
the
it.
state appealed it all, which stayed everything. And so at this point, the law on whether or not Judge Murphy was right or not is all up at the fourth, and it stayed. We can't determine that in a stayed case. It stayed.
You can't talk to the state and decide what this applies to.
I just argued what I have to argue, Judge. You're saying it's stayed for only one purpose, but not, the answer is we are stayed and unable to do so.
So you don't even know what evidence the order is.
No, I believe we do, and I think that's on appeal at the 4th. But during a stayed case, we cannot do those things. And that's why it hasn't been done, not because we haven't wanted to. They appealed it, it stayed.
Unfortunately, to also remind the court, the defense did cross appeal, so even stuff that would remain in is also potentially can now be excluded should the 4th rule in the defendant's favor.
And that's still pending before the 4th.
But you don't agree with their request, you want to go forward.
That's what he said.
Sounds like Melly does not want any more delays. He wants the trial to go forward. He doesn't give a shit about anything anymore.
Just 5 minutes. It would take more than 5 minutes, but it can be done easily.
Well, again, and Judge Murphy did this not longer than me, but that's what he ordered you to do, 568 days.
Which,
That's what he ordered you to do. He didn't ask you to do it, he ordered you.
Damn. Both sides didn't follow instructions from Judge Murphy 568 days ago.
But he didn't do that.
And I'll
I
tell
don't
you,
have the benefit of sitting next to him when he went through all of this, so that's why he ordered you all to
and all
say
we would
what
do,
it is.
and all we would be doing is reciting his order.
Who's arguing at the 4th? That's what I was looking to do. Who's arguing? So what if their first question is, what evidence are we talking about?
Everything from this date to that date.
What date? I don't know what all the exhibits are. How would I know that?
That is,
You all know that. I don't know that.
that is part of the problem that we haven't even gotten to some of the motions. When we're talking about over 2 million Instagram lines, nothing is delineated that I am suppressing line 1,287,000.
You hear these statements, bro? This is what happens when the state pulls Instagram files and they have to hand over everything, and it's like millions of pages and shit.
I have a pending motion that's been pending now for well over a year, probably over 2 years now, or we're approaching that. And that is for the state to delineate what they are intending on using, because if they have 2 million lines of Instagram messages, we can't be prepared for that. Are they introducing all 2 million? Are they introducing just some? And Miss Buckaloo,
Bro, I'm going to zoom in on the judge's face there. He is so annoyed right now.
let's not hear that motion. We're not ready for it yet because we don't know exactly what we're trying to introduce. So we have not had that heard. So I do not know what specific line the state wants to introduce that would be suppressed by that order, because they have not told us. So all I am left with is that sole period of time. I have nothing else I can say. I can say every Instagram from such and such a date to this date, because I do not know what they're intending on using.
I do find this case to be under the most compelling circumstances. Mr. Devins, as I sit here today, has been in custody for 2,339 days.
It sounds like he's going to vacate the stay.
Besides Mr. Devins' cases, which I've removed, this division currently has 38 other cases, special set of trial. 22 of those are murder cases. Numerous of those are death penalty cases. Right now, this division has trial special set in December of 2026. Which means any new trial they talk about will be starting in 2026.
Did you just hear that? He said if you were to delay this September trial, the trial wouldn't be able to start until 2027. There's actually no way that happens. He's not going to do that.
The future of your business is here. With Wix, you get advanced AI capabilities for more customization, more time, and more growth. Speed up your website copy with an AI text generator that delivers a consistent brand voice to every corner of your site. Unlimited unique visuals enhance every piece of content you create.
The entire balance of September and the entire month of October, we try Mr. Devins' case and Mr. Henry's case.
Oh, he just said that he's already marked off the entire month of September and October for this trial.
So if the defense doesn't object, or the state's objection, we are going to go forward on September 10th. The state's motion to reconsider oral order moving forward with September 10th, 2025 trial date is going to be denied.
Boom. Trial's not getting delayed. He's saying no matter what, this should start on September 10th. Thank God. I want this shit over with, bro.
Again, the only thing that would interfere with those is if I happen to be in a penalty proceeding.
What did he just say? Let me see if I can read his lips.
9 o'clock to 12 noon. Again, the only thing that would interfere with those is if
Dude.
in the trial it started. I then have September the 5th.
Bro is not happy today. He don't want no more delays. He's snapping at his family, I think. So he just told them we have 20 hours of court before the trial starts, where we have to handle all motions and everything before the trial starts.
For a testimony as it relates to his homicide case, but they're going to go into another area, and that's where we'd be seeking that protection with the in-camera review of the open investigation. Well, they proffered some of them, and I understand what it's like to be a defense attorney. I kind of know where they're going to go, Judge.
Okay, that request was respectfully.
So the court just clarity, you're refusing an in-camera hearing for the fact that it's an open investigation.
You want me to bring a witness in the jury room outside the presence of the public?
Yes. With a court reporter. This is the guidelines that are outlined under Rule 3320. The court so the court is aware to create a record that there's an open investigation.
They're trying their hardest to give the judge details on why they think it's an open investigation still and an in-camera review, but the judge's like, no, we don't have to do that.
I can show you the investigation just to point out different opinion. That's the point of why I'm asking, just for purposes of the record.
How long would that last? No. You tell me this could be ad infinitum for any
I can discuss that with the court in camera, how long the investigation is going to take, but I'm not prepared to do it in front of.
No, but law enforcement gets to decide that. That's your position. They just get to decide.
Well, it's also dictated by when and how evidence is received, where it leads, how long it takes to get that information, how long it takes to interview those witnesses, et cetera, et cetera.
Are you kidding me? We could circumvent the code. Like evidence from you. That requested. I mean, you didn't file a motion. You're making this in the world.
I don't know who I can.
Somebody did.
Yes.
I don't know. The state attorney's office signed their name and said, this person has personal knowledge about this thing, right?
Yes.
Okay. The rules are the same there in any other sort of.
Well, they're having a head like a straight face off. I told you.
Shooting them down. She's a witness. She got to answer all questions at a deposition. Thank God the judge put his foot down. Can you imagine if this judge just delayed the trial to 2027? Hit subscribe.
That's a cuff word, bro. We'll go to the next one. Cool.
I'm almost like an old man at heart. I don't know why I've been like that since I was young. Even with producing, I still like making beats the old way. But
So Ynw Melly's trial is supposed to start in a couple of months. And of course, we've been having these hearings and there's been so much back and forth between the prosecution and the defense. We even saw a couple of weeks ago, Ynw Melly getting into it with his own defense team. They were trying to hold off on the court proceedings. They wanted to wait. Ynw Melly said, hey, listen, I can't do this anymore. You guys need to get us to trial. We need to get this over with so I can figure out what's going on. Now we've got another situation. Judge Fiend is going to have to go after the prosecution again for trying to pull some BS and go above his head. He's not happy, and neither was the defense. Y'all check this out. Wow, wow, wow. Let me know if y'all could hear okay.
We'll see.
Because the mics in this courtroom sometimes are a little bit iffy. Here we go.
Yeah, I don't think it's something that before dates were available. I think it's August 16th, 17th, and September. No,
The lawyers, Mr. Haddad, your co-counsel or your opposing counsel, they can give you the dates and times. I'm in another capital case right now. I have 4 hearing dates left available between now and September the 10th. I gave the parties those 4 dates, and I'm holding all of those dates and times open only for these 2 defendants. So anything that you need me for, okay? Yes, sir. Okay, so that takes care of Mr. Henry. Mr. Mathis is Mr. Harris's client, so let me just skip on that one for a second. So the bottom of page 2 is Janelle Demmons. I've got Mr. Benjamin here, Mr. Wilson here, Ms. Liberty here. Likewise, Mr. Bruce in person, Ms. Collins on Zoom. So I got the following. I got a state motion to stay the July 9th order setting the trial on September the 10th. I got the state's motion to stay order compelling Detective Luna to answer certified questions and
All these motions to stay. They don't want to move forward.
To Apple iCloud that I previously ordered to be disclosed to me. And then lastly, I got a defense motion to require the state to divulge the existence of other search warrants involving Attorney Raven Liberty. I did read the motions as well as all the authority and the rules.
No, this is his second trial.
I also read the state's petition for writ of certiorari that was filed with the 4th District Court of Appeals on July 14th, 2025. So let's just take them in order. State the motion to stay the order compelling Detective Luna to answer certified questions and order compelling affidavit to Apple iCloud. Anything else that you want to tell me to support the motion?
No, I think the court's aware of the motion, the fact that the state is now officer.
All right, defense, your position on their request.
I think you already ruled it.
All right, so let me, on this one, I'm going to grant it in part and deny it in part. Okay, I still want you to turn it over to me. So that order, denied it to that. I want you to turn the affidavit over to me. As to the first part that I ordered the detective to answer the questions, that's the sole issue that's been raised in this petition for writ of certiorari to the 4th DCA. They are seeking review of the trial court's order compelling the state to permit the deposition of an investigator in an ongoing wholly separate investigation and conclusion of their petition, page 27, it says, the state respectfully requests that this honorable court grant the petition of writ for certiorari and quash the trial court's order compelling Detective Luna's testimony, and thus preserving the integrity of the unrelated ongoing criminal investigation. So as to her testimony only, because you're going to turn the affidavit over to me, state paragraph 7 of your motion, you're asking it to be stayed for 30 days?
Yes, Judge, I think we have 30 days to file the hopefully the court will give us an answer then, or they'll say it if they're taking
So many delays. Crazy.
So over the defense objection, and I certainly understand the defense's objection, I think I'm compelled to grant that part at least for 30 days that the state's asking for. Of course, pending I hear something from the 4th DCA, and hopefully I'll hear something from the 4th DCA sooner than 30 days, and that would resolve the issue.
Well, Judge, I believe we already ruled on that particular issue.
Yeah, I get it.
And what I suggest you consider is that opposed to staying already bigger. We'll wait. We won't wait, but depending on what the 4th DCA does, usually they act on writs like this rather quickly. I would ask Your Honor not to stay for the 30-day period. We'll agree to wait a week to set it down.
You want me to stay it?
Yeah, it's a mess,
for 30 days, or from when we hear from the 4th DCA, whichever date arrives sooner. And that's fine. If they deny this, it's hard enough they deny your depo the next day.
Exactly.
Because I already ordered that you could.
Yes.
But they're going to tell me they're the higher authority, and they're going to tell me I got that one wrong. I guess that's what they'll say. I don't think so. She's made with it. Do that as a thing.
May I have 1 second? Sure.
Judge, while they're doing that, I just have one thing on the record. Your Honor,
You know, Melly is not feeling that.
That they filed, the state filed, or the AG filed, in the 4th. I read it a couple of times last night, and I was aghast at the disingenuousness for them not even telling the 4th that Your Honor made a ruling and defined what an ongoing investigation was and denied there's an ongoing investigation. So the 4th, looking at that paper, will not even know what your ruling is until somebody else raises their objection.
I don't know that I necessarily disagree.
Podcast editing is so frustrating. That's why Riverside makes editing super simple and fast. Check.
My opinion on it. Yeah, I read it. All right, so that's that one. So the order, that's going to be granted in part. It's denied as follows. I still want the state to turn over the affidavit in support of the warrants to me, so I can have them and review them. And if we get a ruling from the 4th DCA, I can distribute those accordingly. It stayed only as to the deposition of Detective Luna compelling her to answer those questions for the period of 30 days, or the alternative until we hear from the 4th District Court of Appeal, whichever of those dates comes sooner. So I'll enter a written order that reflects this.
Dang.
I'll be bringing over this out. All right, the state's motion to stay the trial date, September the 10th. State, anything else you want to tell me?
No, Judge, same issue.
So there's September 10th.
My understanding is that the Attorney General is also going to be pushing forward through the open appeal to stay.
Yeah, so at this point, the state's motion to stay the September 10th trial date, that's going to be denied because there is no pending appeal right now. But if that changes,
Course going forward.
with this, come back and see me. I'm not
Good.
expecting anything in the future, but right now, the only relief that's been sought by the 4th DCA to the 4th DCA with regard to Detective Luna's testimony being compelled, nothing else. So the state motion to stay, my order setting the September 10th, 2025 trial date, that one respectively is going to be denied. I'll let you go for the written order. Both cases remain set for trial September 10th. Lastly, defense, the motion required the state to divulge the existence of other search warrants involving Attorney Raven Liberty. Did read the motion. I think that's just required a yes or no answer from the state. Is there anything else you want to know?
Yeah, and that was going into Raven Liberty's phone being picked up. She wanted to know why. They were going to tell Melly, talk to Melly about it, and the judge essentially was going to let Melly make a decision on whether he wanted to keep his current team or let them go because of the issues that they're having with the prosecution and the DA's office, essentially. It's just a whole mess, man. It's a whole mess.
Well, it does require a yes or no, but if there's more than one, there's the number of warrants, because the last warrant, the only warrant position 23.
Yeah.
Or 23. So they may have issued warrants on her 24 and also 25. So we would like to know the number of witnesses.
Just to augment that, Judge, one comment or one argument. The state got up here and exhaustively argued the last time we were before Your Honor that this is a different case, this new case of the investigation of Ms. Liberty. I just want to bring it to the court's attention that it is an allegation of witness tampering. That's what the allegation is in what little we were able to see. What witnesses are being tampered with? I would bet body parts, it's a witness or more in the murder case. So it's not some unrelated, absolutely, attenuated issue. It's about this case, the murder case, a first-degree murder, punishable by death, and the witnesses the state are going to come. So I just wanted Your Honor to understand why we're seeking at least the existence of and the number of warrants there may be, so we don't get surprised again on this kind of stuff.
I don't need to. But the state from day one, while I was warning about the war, has come into this court numerous times and said two things. One, it's interrelated to the murder. And two, they're going to use some of the tampering evidence, like they're going to try to as consciousness of guilt in the case. And they represented that from the first day we learned of the warrant, and they have gone by that premise as we stand.
State, your response to their request.
Because we're going to be objecting again. This goes to the fact that there's an open investigation. Unfortunately, no matter how I potentially answer this question, it opens up a can of worms. But I respectfully am going with this still remains an open investigation, and I'm not willing to disclose anything at this point in time based upon, how far-reaching or not far-reaching it may be.
So they're still withholding information that Ynw Melly could use to make a decision moving forward. They should be able to have all of this information if it applies to the trial. They're saying, oh, that's an ongoing investigation. Come on, guys.
Okay. So over the state's objection, I'm going to grant the defense motion.
Okay, thank you, Brian.
To require the state to divulge the existence of other search warrants involving attorney Raven Liberty. I'll enter a written order. State, I'm going to give you by the end of the day. I think this is as simple as sending an email to Mr. Benjamin and the rest of the defense team and saying either no, there aren't any other warrants. There are, but I would view if there are additional warrants, I would view them no differently than what we've already done. I think the defense would be entitled to a copy of the warrant. And I think the defense would be entitled to a copy of what was returned as a result of the warrant. And then as far as the affidavit in support of said warrant, again, that's something I'm waiting for the state to get that.
Understood. Just so the court's aware, I've already consulted the AG on this, and most likely going to incorporate the court's ruling today into the writ that's already been filed, but I'm going to consult with them first, and I'll let the court know which way they intend to handle this.
So you want to put 5 days on that then?
I'll have an answer. Honestly, I think I'll have an answer by the end of the day. If you just give me until tomorrow, at the very least.
Okay, so the defense motion is granted over the state's objection. And need to disclose that's a yes or no. And if so, how many additional warrants have been sought?
Good.
Involving attorney Raven Liberty, and that's due by the close of business tomorrow, which is Thursday, July 7th.
Well, yeah, Les asked a great question. He said, why is there still an ongoing investigation if they have filed charges against him? Because his attorney, his current attorney, y'all saw him sitting next to, Raven Liberty, is being accused of witness tampering, and that applies directly to the case. So what the DA's office is saying is like, although while this is directly related to and tied to the case, we don't feel that we should have to give the defense information on that ongoing investigation, why we're looking into Raven Liberty, what we're looking into Raven Liberty for, and what possibly could be other warrants that were issued for her information. What the defense is arguing is because of that, and because it relates directly to Ynw Melly, he has constitutional rights to know and understand what's going on so he can decide if he wants to keep Raven Liberty as his attorney, if he wants to keep his other attorneys on his team as well. So now that's their way, the defense's way of finding out more information of what the prosecution's up to. Interesting game of back and forth, but as you guys heard, Judge Fiend ruled and granted the defense's request.
Order as such. State, anything else I can do for you regarding Mr. Devins today?
No, Your Honor. I'll be filing motions as the court has suggested in terms of severance, and I'll also consult the Attorney General in terms of writ if there's going to be a separate motion or a separate petition, or whether they're going to file it in the existing bill. Which is what my understanding is going to be. They're going to file the in the existing bill.
Excuse me, did you say you were filing a motion for severance?
When it comes to Raven Liberty, there's a whole lot
Fred,
of
I'll
nothing there.
contact you. We'll figure out how best to handle it, but I need to talk to Ms. Buckler and Ms. Collins as well in terms of how to do it, because I'm not good on this. I have to talk to my superiors.
Anything else? Mr. Haddad, anything else I can do for you today? No, sir. Okay, so listen, those 4 motion dates, I've already instructed my judicial assistant, and I'll send her another email today that those 4 dates are just for you all, whatever dates and times you want to use. I'll sign the orders today, and I'll see you, sounds like prior to those trial dates.
Thank you.
As far as Mr. Mathis, Mr. Haddad, you want to stand in for Mr. Raris today? I'm just going to leave Mr. Mathis's case set for trial September 20th, with the understanding that my intention is to go forward on the murder cases. The tampering cases were just set at the same date as placeholders for lack of a better term.
And that's it for Ynw Melly. Dirty, nasty games this prosecution's playing. They've just delayed. We are, what do you say, September 10th? We are less than 7 weeks away from getting into this Ynw Melly trial. Y'all know we're going to cover it here. Let me know what you think about this. Is there going to be something there when it comes to Raven Liberty? And why is the prosecution continuing to push back against the defense having this information to present their case? Doesn't make sense. Judge Fiend, he's been abundantly patient with them when it comes to ruling on this, but it seems like the defense is getting all the information they need. Let me know what y'all think in the comments and in the chat.
Watch to the end for a discount code to Restream's upload and stream. Being a content creator.
Ynw Melly appeared in court for motions. The judge slams the state for filing a petition to get a higher court to review his rulings. The state is desperately trying to delay this trial. They've even gone to a higher...
They're going to tell me they're the higher authority, and they're going to tell to the 4th DCA.
In what little we were able to see. What witnesses are being tampered with? I would bet body parts is a witness or more in the murder case. So it's not some unrelated, absolutely, attenuated issue. It's about this case, the murder case, the first-degree murder, punishable by death, and the witnesses the state are going to call. So I just wanted you to understand why we're seeking at least the existence of and the number of warrants there may be, so we don't get surprised again on this kind of stuff.
But the state from day one brought us learning about the law. Has come to this court numerous times and said 2 things. 1, it's interrelated to the murder. And 2, they're going to use some of the tampering evidence. They're going to try to place consciousness of guilt in the case. And they've represented that from the first day we learned of the warrant, and they have gone by that premise as we stand.
State would be responsible for their request.
If we're going to be objecting, this goes to the fact that there's an open investigation. Unfortunately, no matter how I petition answer this question, it opens up a can of worms. But I respectfully am going with this still remains an open investigation, and I'm not willing to disclose anything at this point in time based upon, how far-reaching or not far-reaching it may be.
When will you accept it's not an open investigation? They literally had to go all the way to a higher court, and they're probably going to be bitched again that it's not an open investigation at a certain point. Honestly, that's what's going to happen here.
Okay. So over the state's objection, I'm going to grant the defense motion to require the state to impose the existence of other search warrants involving attorney Raven Liberty.
They have to show all the warrants. Oh, they're so bad. They definitely didn't want to show them all the warrants they got.
A written order. State, I'm going to give you by the end of the day. I think this is as simple as sending an email to Mr. Benjamin and the rest of the defense team and saying either no, there aren't any other warrants, or yes, there are. But I would view them. If there are additional warrants, I would view them no differently than what we've already done. I think the defense would be entitled to a copy of the warrant. And I think the defense would be entitled to a copy of what was returned as a result of the warrant. And as far as the affidavit in support of said warrant, again, that's something I'm waiting for the court to do.
Understood. Just so the court's aware, I've already consulted the AG on this. They're most likely going to incorporate the court's ruling today into the writ that's already been filed, but I'm going to consult with them first, and then I'll let the court know which way we intend to handle this.
So you want to put 5 days on that then?
I'll have an answer. Honestly, I think I'll have an answer by the end of the day if you just give me until tomorrow, at the very least.
Okay, so the defense motion is granted over the state's objection. Indeed, it disclosed as a yes or no. And if so, how many additional warrants have been sought involving attorney Raven Liberty? that's due by the close of business tomorrow, which is Thursday, July 7th.
Fred, I'll contact you. We'll figure out how best to handle it, but I need to talk to Ms. Buckaloo and Ms. Collins as well in terms of how to do it. I'm not.
Motion for severance. Oh, so the state doesn't want Bortland and Melly to be tried together, is what I'm guessing here, and they're going to file a motion for that.
Okay, so listen, those 4 motion dates, I've already instructed
He
my
looks pissed, dude. Sorry, it's not funny, but
judicial assistant, and I'll send another email today that those 4 dates are just for you all. Whatever dates and times you want to use, I'll sign the orders today, and I'll see you. Sounds like prior to those ground dates on September.
fist bump. God, I wish I could understand what they're saying here. And that's it. So it sounds like the state kind of got shit on today. And the judge was like, I'm going to deny all these, but let's see what the higher court says. And if they think I'm wrong, I don't think they will think I'm wrong. But thankfully, this judge is not playing games, and the trial is going on September 10th. So, yeah, hit subscribe. Love you guys. Peace out.
We was about to resubscribe to, but why?
Crazy. So, as many of you may know, Ynw Melly is still trying to figure out when his court date's going to be. There's been back and forth between the prosecution, the defense team, Ynw Melly, Judge Fiend, and now we are actually going to get a visual and see that Ynw Melly is really in charge of what's going on, because he has an instance here where they're going back and forth with the judge and trying to figure out what they're going to do about this court date. And Ynw Melly is just sick of being in jail. You can tell he wants to get this trial done. Already had to go through it once. Know he's got to go through it again. And it's interesting to see this interaction here. Y'all check it out and see what went down.
To reconsider oral order moving forward with the trial on September the 10th. This trial date remains set on September the 10th. We did that last July 8th, 2024. Although there's no motion to continue filed. I did read the motion. I guess I'll treat this as a motion to continue. I did read the authority cited therein. I did read again, Florida Statute 924-071. Additional grounds for appeal by state, time for taking and stay of cause. I likewise again reviewed the omnibus order on defendant's motion to suppress 1 through 13, which was entered by Judge Murphy on December the 20th, 2023. I also reviewed the order from Judge Murphy denying the defendant's motion to set aside stay, an order granting the defendant's motion to modify the stay to allow discovery to proceed. That's entered May 2nd, 2024. I likewise reviewed a Fourth Supreme Court case called Mitchell versus State, 911, 7-2nd, 1211. Supreme Court case, September 2005, regarding serious constitutional issues that are implicated if the state were to be automatically entitled to stay the effect of the decision at first of the state in criminal proceedings. So, understanding that I've already looked at all of that, state, anything else that you would want to tell me in support of your motion?
No, Judge, my motion basically covers the previous court's orders, the statute, the case law in terms of how this case is stayed.
Okay. Defense, you all want the case to be stayed?
Oh, here we go.
The state says it's stayed, so should you agree with their motion? Or do you not agree? And we have one more. Sure.
All right, so now this is where they confer with their client, and check out Ynw Melly here. I was honestly surprised by this interaction. They're explaining everything to him. This man's done. He's ready to get out of there. He said, no, he said, let's go. He said, I'm tired. Dang. He's done. Melly said, let's go. Let's get this over with. This man's ready to get it over with. So check out what happens next. He said, I want to be out. His lawyer said, don't talk to me like that. And Melly just laughed at him. Wow. Tensions are high.
Yes, sir.
This dude has been in there so much of his life. It's insane. And he said, against our advice, our client wants to proceed. Wow.
Against our advice, our client wants to proceed.
You don't, you object to their request for you to determine if it's automatic stay.
Based upon what our client has instructed us, yes, sir.
Wow.
Okay, so let me make the record crystal clear on this one. I am aware that 924-071 calls for an automatic stay while the state is.
Melly's ready to get out.
They want to appeal in this particular case. Mr. Dennis, they want to do Judge Murphy entered this motion to suppress, which is the subject of the appeal. He entered this order on December 20th, 2023. That was 568 days.
Jesus.
And in that order,
A year and a half.
he says, again, the court has not been moved to consider the suppression of specific evidence. It is up to the party to inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible pursuant to that order. When we were here on the defendant's renewed motion for bond on May 6th, that was 65 days. I asked you all, had you gotten together and figured out what specific evidence
They're
falls within the
proposing they
suppression
delay court. Excuse
order? I'm
me.
going to guess that hasn't happened.
No, Judge, I made the proper to the court last time as to what that.
Imagine being able to build anything just by thinking about it. Meet Base 44, a complete AI creation platform made for anyone with an idea and a drive to bring it to life. Describe what you want and watch it take shape. You can plan, customize, and expand in any direction. From tools built for one to platforms ready for many. From passion projects to enterprise-grade systems. Everything is built in and ready to launch. It's a new world of creation where you can go as far as your imagination takes you. Can you imagine it? Let's make your dream a reality right now.
Basically, penalty for lack of a better.
No, they were aggravators. They go to membership in a gang. There are things that the jury would have to find before going into penalty.
Not aggravated as to death, but
Sorry.
aggravated as to the gang. That was charged. He was charged in committing the murder for the furtherance of the gang, which is an aggravator in terms of the.
Something that they would have to find by way of an interrogatory.
Yes.
Yes.
That's tough, man.
Objection, that's not
correct. You all don't agree on it.
No, what you just said we do not agree on. Here is.
Counselor, have you all done what Judge Murphy ordered you to do in 2023? It is up to the party to inform the court as to what specific evidence falls within the suppression order and what specific evidence is admissible pursuant to this order.
Now, may I answer the question this way? At that time, the state appealed it all, which stayed everything. And so at this point, the law on whether or not Judge Murphy was right or not is all up at the court, and it stayed. We can't determine that in a stayed case. It stayed.
You can't talk to the state and decide what this applies to.
I just argued what I have to argue, Judge. You're saying it stayed for only one purpose, but not. The answer is we are stayed and unable to do so.
You don't even know what evidence the order is.
No, I believe we do, and I think that's on appeal at the fourth.
So you guys are asking what happened. basically what happened is they're talking about evidence and they're talking about a motion to stay. They were trying to delay this trial even more because they just haven't been able to get on the same page when it comes to evidence, when it comes to trial proceedings. We had an issue with Raven Liberty. We've had an issue with the judge having to tell Melly he gets an opportunity to decide if he wants to keep his attorneys or not. So there was almost a delay there. There's just been delay after delay after delay after delay. And now we have another issue here where they're going back and forth about evidence. It just seems like that this trial is always something. And again, keep in mind, this is the second time this is happening. So I'm not going to continue to play the rest of the court coverage here. You guys can check this out. I'll leave a link in the description, but let me know what you think about this Melly just wanting to get to court. Was it a mistake by him rushing things along and moving forward? Should he have waited, made sure they get everything together? Y'all let me know what you think in the comments in the chat.
The closing arguments for the Ynw Melly murder trial just happened.
Okay, so yeah, man, it definitely seems like they're trying to hold on. It definitely seems like they're trying to railroad him and trying to keep pushing back his date, so I can see why he got aggravated. As far as it goes with what the judge was saying, he was saying some real shit. The lawyer, he was saying some real shit. He was like, how are you gonna sit there and try to make a new case, new evidence, and charge him with a new charge? So, man, prayers for Ynw Melly, man. I hope that in September that everything gets resolved and there's not none of this shit where they talk about 2027 for the next retrial or whatever. Y'all let me know in the comments what y'all think about this situation, man. And we appreciate everybody liking, commenting, sharing, subscribing, hitting the notification bell so I know y'all there, so I can throw it to you when it's in the air, man. We gonna keep on going and going and going and going. Like I said, man, let's get us to the 20 more subs so we can get to 4,000 subscribers, man, so we can do this giveaway. We out here. We gone. Peace.